Yeah, hey folks. Yeah, I just wanted you to see what I'm seeing right outside my window. I mean, it's a glorious sunset. And yeah, if anybody wondered why I live where I live, well, yeah, this is one of the reasons. Almost no neighbors, fields, and glorious sunsets. Ah, it's almost sad I'm going to stream. Sometimes I just pick up a chair, sit outside and have a cigar and something to drink and just feel the calm. Yeah. Okay, that's a minute and a half of sunset. Let's get back to me. Hello, folks. Hello, folks. I'm going to put on the lights. Hello. There. Something like that. Yeah. Hi, folks, and welcome. We are going through Mr. Steele's and Mr. Adams' affidavit to yeet the judge. And it is good. It is really good. This is the supplement to motion to recuse Judge Glanville. Because when they filed the first one, the ex parte transcript hadn't been released yet. So now they are supplementing it, and it's good. It's really good. And now, if my voice breaks, because I'm coming down with it, I have one of these, you can feel it in the back of your throat, and it just won't break out to real cold. And it's annoying because if I'm going to get a cold, I want it now and not closer to when I go to the States for the road trip. And so, but it hasn't yet. So here I am. Yeah, if I move further to the north, I don't have to worry about sunsets. I mean, I am roughly a good drive north, and it's the polar circle, and currently it is midnight sun. Are there anything else ghost than man calls? I don't know. Oh, all right. Thank you all for showing up to my little channel, and I got a bunch of new subscribers the last month. I mean, I went from 7,100 to how many is it now? 8,200. So over 1,000 in less than a month. So thank you, folks, for showing up and subscribing and everything. Now hit the thumbs up. All the YouTube thing is. Hi, Jody. Hi, Polly. Hi, Nokursan. Hi, Gwendolyn. Hi, Ghost. Precosint. Gliano. And everybody else. Say hi in chat and where you're from, folks. Yeah. Okay. Let's not. Yeah. Let's just. There it is. Here it is. Dun, dun, dun. Oh, I forgot this one. There. Dun, dun, dun. Sorry. All right, let's get right into it. Let's have that up here so I can read from it properly. There. In the Superior Court of Fulton County, State of Georgia, v. Jeffrey Williams, Judge Glanville, defendant. Supplement to motion to recuse Judge Glanville. comes now Mr. Jeffrey Williams by and through undersigned counsel, and hereby timely files this supplement to motion to recuse Judge Glanville in the above reference case. In support of this motion, Mr. Williams shows as follows. This is number 1 out of 64 paragraphs. So we'll see how far I can get. Cheers. This supplement to motion to recuse Judge Glanville, as well as the attached joint affidavit, Exhibit A, is timely filed as Uniform Superior Court Rule 25.1 mandates. The time for filing a motion to recuse shall not be later than 5 days after the affiant first learned the grounds. This... hold on. I forgot my nicotine pouches. Darn it. And enjoy some nice melody while I'm... All right, I'm back. Don't start with nicotine, kids. It's bad for you. Now, this motion applies to lawyers Love and Hilton in addition to Judge Glanville, as all 3 are material witnesses in the case at bar, and all will be called by Mr. Williams during trial to show judicial and prosecutorial misconduct. See Reed v. State from 2022. Footnote 2. This motion also timely moves to recuse the Honorable Judge Krause based upon the fact that she sits on the Fulton County Superior Court bench with Judge Glanville, and that in April 2024, Judge Glanville contributed $2,000 to the Honorable Judge Krause's re-election campaign. Now, this second part here has been amended. Judge Krause did not donate $500 to his re-election campaign. And undersigned counsel derives no happiness when filing this supplemental motion. However, let justice be done, though the heavens fall. Actually, the heavens will not fall by unmasking biased and unethical members of the bar. Right out of the gate, it is. Whoop, here we go. So the supplement, these are just, I mean, there are so many footnotes here, it's ridiculous. 5 days after the affiant first learned of the grounds for disqualifications. I thought I was on. Am I not on? No, sorry. Here we go. Damn, my cold is making my brain go kaput. This is what I was going for. The joint affidavit of Brian Steele and Keith Adams, ESO. Sorry, folks. I went to the wrong chapter. Yeah, I know the footnotes are really fun in this one, but I'm here for the joint affidavit. And it starts off as everyone, we are over the age of 18 and suffer no legal disability. We make this joint affidavit based upon our personal knowledge. We are counsel for Jeffrey Williams in the above style case. It is timely filed. Affidavits hereby expressly adopt and embrace all statements made in the motion to disqualify, recuse Judge Glanville, and the joint affidavit here attached thereto date June 17, 2024 hearing, and rely on that timely filed asserted motion to recuse, as well as the affidavit in total. Hearing for total. And here it goes. 5. Judge Glanville met with lawyer Love, the Honorable Attorney Bumpus, lawyer Hilton. See the shade here? Immediately, the shade. Lawyer Love, lawyer Hilton, and the Honorable Attorney Bumpus. The shade in that sentence alone. At times, the court reporter, sworn witness Mr. Kenneth Copeland, members of the District Attorney's Office, including but not limited to Fulton County District Attorney's Office investigators Long and Hamilton, as well as members of the Fulton County Sheriff's Department, outside of Mr. Williams and his counsel's presence, and discussed critical parts of Mr. Williams' case in violation of Mr. Williams' constitutional rights to a fair tribunal, right to be present, right to due process, right to a fair trial, right to assist counsel, and right to confront witnesses. The United States Constitution Amendments 1, 5, 6, 14, as well as Georgia Constitution Article 1, Section 1, paragraphs 1, 12, and 14. The purpose of this ex parte meeting between lawyer Love, lawyer Hilton, and Judge Glanville was to act in unison in order to influence sworn witness Mr. Copeland to testify against Mr. Williams. Exhibit B. There was absolutely no lawful purpose for this ex parte hearing to occur. To wit, there was no allegation by Mr. Copeland that he was somehow threatened. There was no allegation by Mr. Copeland that he was not satisfied with his counsel. There was no allegation by Mr. Copeland that he needed to meet with Judge Glanville. Instead, this ex parte meeting was orchestrated by lawyer Love, lawyer Hilton, and Judge Glanville to convince Mr. Copeland to testify against Mr. Williams. This influencing a witness meeting eviscerated any appearance of regularity of the tribunal and demonstrates, at the very least, that Judge Glanville is biased for the prosecution and against Mr. Williams and his counsel. Hold on. I forgot one. What's going on here? Yeah, today I'm mostly reading because apparently my brain is not exactly where it should be. My apologies, but then again, my brain hasn't been where it should be since I was about 5. There you go. 7. Lawyer Love begins this unethical ex parte conference by explaining that the state's reasons for Judge Glanville to meet with sworn witness Mr. Copeland is to impress upon Mr. Copeland that he needs to testify for the same reasons lawyer Love announced in open court on Friday, June 7, to which Honorable Jonathan Melnick, Esquire, abandoned his client. I understand the language, but you need to understand Mr. Melnick had no choice. Because if you, as a lawyer, know that your client will take the stand and probably will lie, you cannot represent that person. So you recuse yourself. Now, so that is what happened that Friday. That he said clearly, if he testifies, I cannot represent him. And everybody knows what that means. Everybody knows. See, YouTube dated on these hours. Yeah, we won't watch that. At this point, rather than acting as a true judge, protecting our court system and its reputation by questioning, quote, why am I meeting ex parte and why am I being used to answer in front of only members of the state of Georgia questions of Mr. Copeland, end quote. Judge Glanville, because he is biased, agreed to help convince Mr. Copeland to testify adverse to the liberty of Mr. Williams. Hi, Ron Barnes, Michael, and Republic, and Elise, and Sir Frank Carter. And yeah, hello, everybody. Good to see you here. Good to see you here. Lawyer Love made untruthful statements about email correspondence with the Honorable Jonathan Melnick. See Exhibit B, blah, blah, blah. Emails with the Honorable Jonathan Melnick, blah, blah, blah. Yeah. Melnick has been on shows where he stated what Miss Love told the judge in that ex parte meeting, that his answer was, his reply was to F off or F you. The real answer was a bit longer. It was not verbatim. If you force my client on that stand, then that is on you, so F you. Because they tried to insinuate to Mr. Melnick that he did wrong. And his reply was in more words. Lawyer Love continues to make false representations, and Judge Glanville knows, if he has paid attention at all during the proceedings, that Lawyer Love makes intentional misstatements of fact routinely. Yeah. If you've been with me for longer than 2 months, you know I've been bringing this up continuously. That Miss Love lies to the court frequently, and she doesn't get into trouble for it. Yet Lawyer Love deflects her misconduct and cites the ethical rules of conduct for attorneys during this ex parte hearing. Lawyer Love explains the need for the ex parte communications, quote, all that aside, we would like an opportunity for the court to address Mr. Copeland, with Mr. Copeland standing counsel present, to allow Attorney Bumpus an opportunity to explain to Mr. Copeland everything that Lawyer Love has just said. Exhibit B. Again, Judge Glanville has thrown away all appearance of propriety by permitting this ex parte meeting to occur at the behest of Lawyer Love and or Lawyer Hilton. Judge Glanville is not independent, is being, quote, led by the nose, end quote, by members of the Fulton County District Attorney's Office. This is because Judge Glanville is a member of the prosecution team. How many times in the past 6 months have I told you guys? How many? Every stream, several times, I have stated Judge Glanville might as well sit at the prosecution's table because he is a part of the prosecution's team. I mean, I said, so I will take this line here. I take full credit for. No, I'm sure Mr. Steele haven't watched my stuff, but I don't care because I've said it for so long. I take full credit. Even though it's undeserving, I still take full credit for it. Then Judge Glanville adopts the wrong law offered by Lawyer Love, that Mr. Copeland will be held in custody until he testifies. Lawyer Love seems to somehow assert that Mr. Copeland can be kept in custody even after Mr. Williams' jury is discharged. Judges are supposed to know, respect, and comply with the law. And here he quotes, objectively, Judge Glanville permits several misstatements of law in order to have Mr. Copeland testify against Mr. Williams in order to assist the prosecution. Judge Glanville becomes an advocate for Mr. Copeland to testify against Mr. Williams by telling Attorney Bumpus how to communicate with the client, Mr. Copeland, specifically that Mr. Copeland is, quote, going to face some pretty significant cross-examination, end quote. And Judge Glanville explains to Attorney Bumpus that, quote, it's all in the message and the packaging in terms of, I think Mr. Copeland is, a savvy person. But, he's certainly going to be subject to a thorough and sifting cross-examination, end quote. Every witness in a trial, every single one, can expect a cross-examination. Somehow, they need to emphasize this. I'm quite sure Mr. Copeland is more aware of that than most others because he's been in a few, not trials maybe, because he often pled out, but Mr. Copeland is not a stupid person. In fact, he's quite intelligent. And he is not scared of anything. or anyone, would he? Let's continue. The fact that Judge Glanville is dispensing legal advice and strategies to Attorney Bumpus, guiding her on how to speak with Mr. Copeland in order to have a client testify against Mr. Williams, is a clear, direct fact that Judge Glanville has forfeited his judicial role. Yes, public room. Completely and utterly inappropriate by Glanville et al. Yeah. This is their conduct, because there are 3 people colluding to break the law. RICO! In this thing, Rule 3.10 states that full-time judges shall not practice law. See also former canon. Now Rule 2. What happened? Former canon 3.b. Oh, no, I know. Sorry. What the fuck is going on? Why am I... Hold on. I'll reopen this. I accidentally started to make some adjustments in the document. I didn't mean to. And I have to find the correct place again. Where did I pass it? Today is not a good day to F up like this. The fuck is going on here? Sorry, folks. There we go. Let's see if I can bring that up again. Yes, I'm boomering. I'm boomering. I'm boomering. Boom, 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 boom. There. See also now Rule 2.10. Judge Glanville is biased against Mr. Williams and is partial to the prosecution of Mr. Williams. Judge Glanville, along with lawyer Love, continues to advise Attorney Bumpus what to tell her client. For instance, quote, part of Mr. Copeland's challenge, Attorney Bumpus, may be that you need to ensure Mr. Copeland, look, I'm going to be here, and if you think that they are asking you a question, they being the state of the defense is asking you a question that is going to bring out other crimes that you are going to be able to look to you and say, can I have a chance to talk with you, end quote. Lawyer Love, who is working in lockstep with Judge Glanville, states, quote, that's exactly right. Lawyer Love then inaccurately bashes Attorney Melnick by saying, quote, there's been an assertion that people are representing Copeland's interest. The biggest concern is Mr. Copeland's best interest, and then they are just not here. There are absolutely no reason that Judge Glanville and Lawyer Love are discussing what Attorney Bumpus should be telling her client, and no reason for Judge Glanville to permit Lawyer Love to ridicule Attorney Melnick. Oh, for fuck's sake. There. This stream will probably not be monetized by YouTube because I get words out that I normally try to avoid to get a few bucks in ad revenue. So this, yeah, let's just hope for the best. Lawyer Love again misrepresents by claiming that the Honorable Attorney Melnick, quote, has been talking to Brian Steele and Max Shard. That's it. He's not talking to us. Why does Judge Glanville hold this ex parte conference and permit lawyer Love to falsely accuse Affiant and the Honorable Attorney Maxwell Short of obstruction and ethical violations by influencing a lawyer-client relationship? This is extrajudicial information that Judge Glanville should have never received. 15. Judge Glanville continued to be a prosecutor of Mr. Williams when he instructs Attorney Bumpus that sworn witness Copeland can invoke the Fifth Amendment if he testifies about unrelated crime. Judge Glanville tells Attorney Bumpus that sworn witness Copeland probably, quote, is, quote, probably thinking about there's a lot of stuff the defense could ask him about that is not known to a lot of people, and Mr. Copeland could also invoke the Fifth Amendment if it was some other particular crime. During this advice on what to explain to Mr. Copeland, lawyer Love and Judge Glanville are speaking with one voice. This has Judge Glanville presuming and pontificating that Mr. Copeland is involved in a lot of unrelated crimes that Mr. Williams, a criminal himself, is aware of saying. This is not Mr. Steele saying that Mr. Williams is a criminal himself. He is asserting what the judge and Ms. Love are talking about. Uh, 16. Thereafter, Judge Glanville and lawyer Love jointly explained to Attorney Bumpus that Attorney Melnick injected himself into these proceedings. The fact that Judge Glanville is having these conversations in the first place, then agreeing with and championing with the prosecution case, mandates even to a casual observer that Judge Glanville is biased against Mr. Williams and favors the prosecution. Yeah. 17. This great bias cannot be more clear when Judge Glanville explains to Attorney Bumpus that she needs to give to sworn witness Copeland the question that the state is going to ask him when he testifies, and to ask Mr. Copeland to tell Attorney Bumpus any other facts that they, meaning Mr. Williams and his co-inductees, might ask about. Further, as long as Attorney Bumpus has knowledge of other crimes that sworn witness Copeland has committed, Judge Glanville states that Mr. Copeland will be fine because the state is only going to get into the questions that was provided to Mr. Copeland. It is ridiculous to claim Judge Glanville is not biased and is impartial. Judge Glanville continues explaining to Attorney Bumpus that the reason she needs to know from Mr. Copeland what crimes he has committed in the past is, quote, the defendants know more about Kenneth Copeland than anyone else, so they are probably going to kind of, end quote. What gives Judge Glanville the right to state that Mr. Williams knows more about Mr. Copeland's supposed bad conduct than anyone else? Mr. Williams hardly knows Mr. Copeland. Judge Glanville has pronounced guilt onto Mr. Williams. Judge Glanville imparts legal direction to Attorney Bumpus on how to prepare Mr. Copeland for cross-examination and how to prepare Attorney Bumpus to object on behalf of Mr. Copeland. Judge Glanville has tarnished this trial forever, as Mr. Williams could never have a fair trial with the way Judge Glanville has acted, both in front of the jury and outside of everyone's presence in the ex parte meeting with Fulton County District attorneys and witnesses. And a bit of passes here. Today, Wednesday, 5 p.m. in half an hour is the last hour when the state can reply to the recusal. I haven't seen it show up yet in my feed. They got a 48-hour extension. I don't know, but if it shows up, I will continue reading this and move right into their answer. The reason they needed more extra time was because Miss Love had a family emergency. I suspect that it is because they needed to find good case law, because they can't rely on Judge Glanville approving of their rubbish case law. Thank you, Tavius. Hey, yeah, I also think I do a good job. Let's continue. Judge Glanville imparts legal direction to Attorney Bumpus. Yeah, we already read that. Judge Glanville has tarnished this trial forever, as Mr. Williams could never have a fair trial with the way Judge Glanville has acted, both in front of the jury and outside of everyone's presence in ex parte meetings with Fulton County District Attorneys and witnesses. 18. These are 64 paragraphs, so we are getting good time here. But let's continue. The conduct of Judge Glanville, Lawyer Love, and Lawyer Hilton has caused them to be necessary witnesses at trial. Affiant intends to call as witnesses and cross-examine Judge Glanville, Lawyer Hilton, Lawyer Love on how many other ex parte meetings the three of them and any other member of the prosecution team have had. Judge Glanville cannot be judge and witness in the same proceeding. I have said this since we learned about the ex parte meeting. How many? I mean, what Miss Bennett? They threw her in jail. Slug went from not wanting to talk at all to very talkative. So how many ex parte meetings has been had in this trial alone? Lawyer Love and Judge Glanville, acting in concert, tell Attorney Bumpus that Mr. Copeland can cancel legal representation because Lawyer Love, Lawyer Hilton, and Judge Glanville have done anything to, quote, clear Mr. Copeland of judicial exposure. Without any reason to believe that Mr. Copeland might be fearful for his personal safety, Judge Glanville injects his safety concern as a hypothetical reason that Mr. Copeland will not testify. Lawyer Love, misrepresenting emails, continues the theme of Mr. Copeland's personal safety. There is no evidence of same. Yeah, I agree. Now, and even if, for the sake of argument, someone in the defendants or other defendants have reached out, I don't think Mr. Copeland would care. My cat just found my guitar. Jingles, what are you doing? Oh, yeah. Cats. You. Where was I? Yeah. Yeah, Mr. Copeland, Woody, is not scared of anyone or anything. He has his Instagram or whatever. He has his own YouTube channel. He's been on stream with Miss Bumpus. He's not scared. So it's ridiculous. But that's their entire... They have asked that of, or tried to ask that of every witness, more or less. Are you scared of the defendants? And nobody is. Judge Glanville tells Attorney Bumpus that Mr. Copeland, quote, has to give testimony, though. I mean, that's what he has to do. Mr. Copeland got to give the testimony, whatever it is, good, bad, or indifferent. The question must be asked. Why does Mr. Copeland have to give testimony? It is because it favors the prosecution, whose vantage point does Judge Glanville view this trial, good, bad, or indifferent, to whose position? Judge Glanville must be recused. Yeah, yeet the judge. Mr. Nokia Sam, Jingles is probably trying to show you don't need to use AI to make music for the show. Yeah, if he keeps attacking my guitar, I will record it. Mr. Jingles theme song. Yes, Ghost. Mr. Jingles is innocent of any alleged guitar interactions. Yes, I agree. The court reporter announced, quote, off the record, end quote. Mr. Williams intends to call at trial Lawyer Love and Judge Glanville to determine what was discussed during this, quote, off the record time period. Exhibit B, pages 22, lines 3 to 10. Yeah, I've been saying this from after my reading. of the ex parte transcript, there's stuff missing. I made that reading in under an hour and 40 minutes, probably closer to an hour and a half. That meeting was 2.5 hours with a combined pauses of 30 minutes. There's a half hour missing. I'm sure of it. And I'm even more sure of it after Woody appeared on Kayla Bumpus' YouTube when he got the question, is the transcript complete? And you saw him go, and he said, you know that. So yeah, stuff is missing. 23. Judge Glanville had the audacity to bring sworn witness Copeland into his chambers without the request of Attorney Bumpus, but at the request of lawyer Love. Nothing is recorded by the court. Let's see, I see Exhibit B. From 9:34 until 10:03, nothing is recorded by the court reporter. Oh. Yeah, I should have just kept reading. Yeah, that's the missing half hour I've been talking about all this time. 29 minutes. Nothing is recorded by the court reporter. Affiant will call lawyer Love, lawyer Hilton, and Judge Glanville to probe what occurred during this time period. 24. Oh. Once in custody, represented by counsel, sworn witness Mr. Copeland is brought involuntarily into Judge Glanville's chambers. Judge Glanville explains, quote, I just wanted to bring you over and let you talk with Attorney Bumpus and see if there is anything that you need to ask of your counsel or Miss Hilton or the state or the court before you bring you out this morning, because we would like to hear your testimony. And it is kind of where we are at this point in time. It is hard to articulate how wrong this ex parte summit is and how obvious it is that Judge Glanville discarded the sanctity of the judiciary to become part of the prosecution team. Judge Glanville is biased, and this case is constitutionally broken because of the conduct of lawyer Love, lawyer Hilton, and another member of their team, Judge Glanville. Why is Judge Glanville inviting Mr. Copeland, a represented party, to ask questions of lawyer Hilton or other members of the district attorney's office or Fulton County or the court? This is beyond comprehension for an impartial, seasoned jurist to act. This is because Judge Glanville is not acting as an impartial, seasoned jurist, but is part of the prosecution team and must be recused. Yeah, the we part here is, yeah, it's as Iris Ramon says, it's wild to say here. Why? First of all, Judge Glanville is supposed to hear the testimony in open court on the record. It's the first time he is supposed to hear the testimony. Why is he interested in hearing it out of court? That one thing in itself should get him thrown off the bench. 25. Lawyer Hilton makes it clear that Mr. Copeland has never stated that he has a safety concern which is stopping him from testifying. Hence, this whole safety concern discussed earlier was totally fabricated by Judge Glanville and lawyer Love. 26. Mr. Copeland states, quote, I have never been truthful a day in my life until I just made this statement right now. This is an oxymoron, as in two things can't be true in this sentence. I have lied all my life until right now. That's an oxymoron. And it's an amazing oxymoron. This is quintessential Brady material. Judge Glanville never uttered a word, nor did lawyer Hilton or any member of the Fulton County District Attorney's Office provide the defense notice as to his Brady evidence. Same is unconstitutional. Affiant intends to call Judge Glanville as a witness at trial, as well as lawyer Hilton, to discuss the failure to reveal this information to Affiant and for the jurors to be able to understand. The jury has a right to know when a judge reads the instruction that the court has no interest in this case except for a fair trial. Same is not truthful, as Judge Glanville is on the prosecution team. Yeah, Copeland says legendary things. Woody should have his own quote book. He could release a book with his quotes alone. 27. Judge Glanville, lawyer Hilton, and lawyer Love will be called as witnesses and have been added to Mr. Williams' witness list as announced by Affiant in open court. The fact these three persons attempted to hide Brady evidence is beyond the pale. Judge Glanville instructed the jury that he has no interest in the case except to see a fair trial. Same is untruthful, and the jurors needs to hear from these three witnesses in order to make the determination on whether the same was truthful or not. 28. Lawyer Hilton gives an inaccurate legal information on whether Mr. Copeland can be prosecuted at all, and gives some far-fetched ideas about the federal statute of limitations and the states of Georgia statute of limitations. Judge Glanville sits idly by and allows lawyer Hilton to misrepresent to sworn witness Mr. Copeland that he cannot be prosecuted for crimes. Anyone with a modest interest in this case would know that the prosecution has called Mr. Copeland an unindicted co-conspirators, and that the supposed RICO conspiracy statute of limitations continues today. Thus, Mr. Copeland could be prosecuted in both federal court and in the state of Georgia for crimes. This is wholly contrary to what lawyer Hilton and Judge Glanville allowed Mr. Copeland to believe. Yeah, I've had that discussion with several people. I'm not exactly sure, because my understanding is that even though he has immunity in this little court, Fulton County and maybe the state of Georgia, but it's only for the crimes in this trial. Now, they claim it is for all crimes he has ever committed, more or less. I don't believe that's true. Now, I haven't seen his immunity deal, so I can't say. But if they also want federal immunity, then the Attorney General of Georgia has to be involved. Now, there are some things in the Georgia Constitution and statutes that says the state can make you immune for federal crimes as well. But I don't know if that applies in this case. Moreover, lawyer Hilton and Judge Glanville do not disclose other Brady supra evidence, as lawyer Hilton explains, that the state can assist Mr. Copeland with finding different places to live. This is part of an agreement that should be revealed pursuant to Giglio. Same was not done. Lawyer Hilton is a witness at trial and will be cross-examined by the affiant on these knowing misstatements to Mr. Copeland and the failure to reveal Brady and Giglio evidence. Same applies to Judge Glanville. 30. Lawyer Hilton then tells Mr. Copeland, who at that time was a represented person, that he can speak with her without Attorney Bumpus present. Judge Glanville did nothing to stop this potential unethical conduct. Yeah, that is a wild statement that Miss Hilton said this to a witness who had representation, that he can talk to her without her present. You cannot do that. You cannot do that. Lawyer Hilton again tells Mr. Copeland that he is immunized from prosecution while Judge Glanville sits silent. That statement is not true, as Mr. Copeland received only use immunity. Oh. See Exhibit F. Ooh. Order of use immunity. Okay, we will read that after I'm done here, because I haven't read that before. That will be completely new. Finally, I will be able to read that freaking immunity deal. However, Judge Glanville reinforces lawyer Hilton's wrong information because Judge Glanville is a part of the prosecution team. Judge Glanville tells Mr. Copeland that he will not be prosecuted for any crime. Judge Glanville and lawyer Hilton are acting as one, not separate, as required by law. Judge Glanville explains to Mr. Copeland that if he is, quote, worried about what the defendants may ask you because they may know your business, you can't be prosecuted of any of those. First, that is not true, since Mr. Copeland was only given use immunity to affiant's knowledge. However, it is clear that Judge Glanville is an assistant to the prosecution because Judge Glanville, in order to help the prosecution, needs Mr. Copeland to testify and gives Mr. Copeland advice about cross-examination. 33. Oh, we are halfway. Hey, we are at the halfway point. Ooh. Importantly, Judge Glanville again asserts that Mr. Williams and the other co-indictees may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. End quote. This presumes that Mr. Williams knows Mr. Copeland's criminal endeavors, because Mr. Williams is a co-conspirator with Mr. Copeland. Judge Glanville is far from acting as an impartial judge. 34. Mr. Copeland again puts an end to any made-up safety concerns and explains that he does not want to testify because he will set a bad example for his family based on his past misdeeds. One must ask, why is this ex parte conference occurring and why does it continue? The only logical answer is that Judge Glanville, lawyer Love, and lawyer Hilton, acting in concert, had an agenda to ensure that Mr. Copeland testifies against Mr. Williams in order to convict Mr. Williams. This is the definition of a biased judge and unethical prosecutors. This trial is constitutionally broken forever because of the outrageous actions of these three, quote, public officials, end quote. Hi, Cece. Yeah, my voice is holding up so far. My voice is holding up so far. Fingers crossed, I will get through all of this without. Yeah, cheers. $35. Lawyer Hilton never provided the affiant the Brady material that Mr. Copeland had told her in the past that he was a quote-unquote liar. Judge Glanville sits mute and does not ask whether this Brady evidence was provided to affiant. 36. Mr. Copeland explained that he never told lawyer Hilton that the Honorable Attorney Melnick was not his lawyer, and thus lawyer Hilton met with an represented party. Judge Glanville does nothing to discuss this potential ethical misconduct by lawyer Hilton, lawyer Love, and the other members of the Fulton County District Attorney's Office. This is because Judge Glanville is also a member of the District Attorney's Office of Fulton County. Yeah. Another thing I've been saying for quite some time now. They didn't know Mr. Copeland was unrepresented. Even if he make that statement to them, they have to go to him, because the last time his prosecution's team had contact with Mr. Copeland, he had representation by Mr. Melnick. They had no other information, yet they didn't care. They went directly to Mr. Copeland, knowing that the last time they contacted him, he had representation. In order for them to get the information, they have to break ethical boundaries. And it's infuriating as F to see this unfold before our eyes. I mean, now we've been talking for this for a month now. And I've been shouting from the rooftop for months and months and months. This is a unicorn of a trial. I mean, we have seen really bad conduct in other trials. This is unheard of. This should, I mean, even with half of these 64 paragraphs, even with 10% of these 60, had they only the 6 first paragraphs here, it would still, in my opinion, constitute Judge Glanville to get a foot in the arse of that chair. Let's continue. 37. Lawyer Hilton told Mr. Copeland that he would be held in custody until, quote, every last defendant had been tried. Not just the 6 on trial, the other ones too. Judge Glanville sits mute and delegates his judicial discretion of punishment to lawyer Hilton because Mr. Copeland does not have to be housed in custody until, quote, every last defendant has been tried. Yeah. Now, I heard that too, and to the judge's discretion, but I've never heard of, because this is just this trial. Everything is in confinement of this trial. To reference, oh, we will hold you in custody until all the other 12 have gone through trial. It's infuriating. 38. Judge Glanville, like lawyer Hilton, attempts to intimidate Mr. Copeland by telling Mr. Copeland that if he chooses to not testify, Mr. Copeland would be held in custody until all 12 coindictees' cases come to an end. This is just not true. In fact, Judge Glanville is not even the judge on the other co-indictees. Yeah, that would put an end to that, because then it's the other judge's discretion. Judge Glanville only has power over this. He cannot order what other judges do. The case is being presided over by the Honorable Judge Dempsey. Again, Judge Glanville and lawyer Hilton failed to reveal to affiant Mr. Copeland's statement that, quote, I told the police whatever different story I could think of to try to finesse my way out of the situation, end quote. Instead of turning over Brady evidence, lawyer Hilton, with the support of Judge Glanville, explained to Mr. Copeland that he can simply testify, quote, I don't recall, end quote. Now they go from advising to instructing the witness on how to answer. That you can't do that. You simply cannot do this. Judge Glanville, lawyer Hilton, and lawyer Love are inseparable and biased against Mr. Williams. Number 40. Judge Glanville advocates for the District Attorney's Office of Fulton County when he tells Mr. Copeland, quote, just tell the truth, end quote. While lawyer Hilton is telling Copeland, quote, just tell the truth, end quote, and let lawyer Hilton worry about the impeachment and Mr. Copeland will not get in trouble. This excuses Mr. Copeland from giving false statements to law enforcement officers with the statute of limitations tolling provision. However, Judge Glanville tells Mr. Copeland to not worry about criminal violations as the commissions of same would not get Mr. Copeland into trouble. 41. Seemingly, Judge Glanville, lawyer Love, and Mr. Copeland spoke, quote, off the record, end quote, as Judge Glanville recounts that, quote, as Miss Love said this morning, remember, Miss Love said if you overtly lie about something, like if you tell bold-faced whopper, then they can indict you on that particular charge. I mean, that particular failed statement, end quote. Thus, Judge Glanville and lawyer Love will be called as witnesses and cross-examined by affiant as to what was discussed, quote, off the record. Judge Glanville is a necessary witness in this case, as is lawyer Hilton and lawyer Love, and hence Judge Glanville must be recused, removed, and disqualified from his high position of, quote, judge, as he has voluntarily, knowingly, and intelligently forfeited same. 42. Judge Glanville also sanctions a lie that is not a, quote, bold-faced whopper, and is allowing Mr. Copeland then to seemingly lie about something that is not a, quote, bold-faced whopper. This is improper. 43. Mr. Copeland states indirectly that if he confesses while testifying to murder, there is no statute of limitations for murder and he will be prosecuted, and lawyer Hilton stated that he will not be charged. Judge Glanville sits mute during this exchange. This Brady/Giglio evidence never made its way to affiant by Judge Glanville or lawyer Hilton or anyone else with the Fulton County District Attorney's Office. This, again, is unforgivable. Moreover, when Mr. Copeland is speaking about murder, lawyer Hilton states that if she knows Mr. Copeland is lying, to wit, knowingly lying on a material matter under oath in a judicial proceeding, i.e. perjury, Mr. Copeland would not be prosecuted for false statements. Again, this is Brady/Giglio evidence that Judge Glanville and lawyer Hilton failed to reveal. Judge Glanville is no longer acting as a person on the judiciary, but is acting along with lawyer Hilton and lawyer Love in an impermissible manner. 44. Mr. Copeland told lawyer Hilton that she knew Mr. Copeland would plead the Fifth Amendment prior to taking the witness stand. Lawyer Hilton denied same. Judge Glanville was silent. This is also Brady evidence and impeachment evidence. This makes lawyer Hilton and Judge Glanville witnesses. 45. Judge Glanville assured Mr. Copeland that he will not get, quote, in trouble, quote, for testifying, and his testimony would then be impeached. Why would Judge Glanville say this? This could be a false statement. This could be perjury testimony. Yet, Judge Glanville is promising witness Copeland that he would not get into trouble. This is not conduct becoming of a judge in the great state of Georgia. 46. Judge Glanville ruled in his star chamber that if the state wanted to impeach Mr. Copeland, the state can do the same, and Mr. Copeland would not get in trouble for that. Why is Judge Glanville explaining and anticipating rulings on what may happen in court? Judge Glanville must be removed / disqualified from the bench of Mr. Williams' trial. 47. Lawyer Hilton explained that even if Mr. Copeland commits perjury, it would be treated as inconsistent statement. This is again Brady / Giglio evidence, not revealed to undersigned counsel. Judge Glanville sat silent and seemingly in agreement with lawyer Hilton. 48. Judge Glanville sat silent as lawyer Hilton told Mr. Copeland that he has spent enough time in prison for YSL. This is extrajudicial information to Judge Glanville that marks YSL as a criminal street gang, a material element of counts in the indictment, including count 1 RICO. This statement marks that persons supposedly associated with YSL are guilty of criminality. This entire illegal and unethical ex parte conversation was during a critical stage of the proceedings for which Mr. Williams, as well as his counsel, had the constitutional right to be present for, based upon the United States Constitution as well as the Georgia Constitution. This Star Chamber meeting also violated Mr. Williams' right to be present, as well as right to counsel, effective assistance of counsel, right to present a defense, right to due process, right to a fair trial, right to a fair tribunal, and statutory right to a fair and ethical prosecution. All of these rights have been denied based upon the improper conduct of lawyer Love, lawyer Hilton, and Judge Glanville, all working together on the prosecution team. Still no response from the state. Yeah, they might hand it in, and we won't know about it until tomorrow morning. So they have until 4:59 p.m. 1 second before the deadline, they can turn it in, and then we won't know about it until tomorrow. And 49. Lawyer Hilton explained to Mr. Copeland that, quote, no one here expects Mr. Copeland to remember every single detail from 2015. Why is lawyer Hilton able to speak for Judge Glanville, who was present but silent? It is because they are on one team. Judge Glanville has denied Mr. Williams of a fair trial and violated Mr. Williams' constitutional rights stated above and herein. 50. Lawyer Hilton and Judge Glanville function as one cohesive engine as shown clearly by the following. Mr. Copeland asked, quote, you can't give me house arrest, end quote. Lawyer Hilton answers, quote, no, you can go home by taking the stand and testifying. That's what you, quote, end quote. Judge Glanville then states, and come back tomorrow. See exhibits. Judge Glanville allows lawyer Hilton to be the judge by telling Mr. Copeland that he cannot have time to think about whether he's going to testify or not testify, and that he cannot be sentenced to house arrest but will remain in jail. This illustrates the fact, that lawyer Hilton, lawyer Love, and Judge Glanville are working together as one. Judge Glanville has forfeited the right to be judged on Mr. Williams' case as he is biased. In fact, a fair judge does not have to keep a person who refuses to testify in jail. There are other punishments besides same, including a fine, house arrest, or whatever else the judge deems appropriate. What legal right did lawyer Hilton have to pronounce punishment upon Mr. Copeland? Yeah. Remember Miss Bennett? She got an ankle bracelet until the end of her testimony. So clearly, and this is on Judge Glanville only, but here it is Miss Hilton who says, no, you can't get house arrest, taking that right from the judge. 51. Judge Glanville fights for the prosecution by stressing to Mr. Copeland, quote, they want your testimony. That is all they want, whatever that may be. Judge Glanville is an advocate for the state. Why does Judge Glanville tell a witness that the state wants his testimony and that's all they want? Why does Judge Glanville care that the state wants a witness testimony? That is not the concern of an unbiased judge. Thank you, Charlie City. Thank you so much. Thank you. Lawyer Hilton, 52. Lawyer Hilton explained that Mr. Copeland will not be charged with perjury, although that is outside of the order of use immunity that was provided by affiant by Judge Glanville. No Brady Giglio evidence was provided by Judge Glanville or Lawyer Hilton. This is legally wrong. 53. Lawyer Hilton and Judge Glanville misstate the law of perjury and gives promises of no prosecution. This again is Giglio Brady evidence not revealed by Judge Glanville or Lawyer Hilton. And in fact, same was hidden from Mr. Williams until Mr. Williams insisted on receiving this transcript. 54. Judge Glanville and Lawyer Hilton are necessary witnesses as Mr. Copeland confessed to them, quote, I did these crimes, I'm telling you that, end quote. Coupled with the earlier statements by Mr. Copeland about murder, which does not have a statute of limitations, Mr. Copeland is telegraphing that he's responsible for the indicted offenses. This is a stretch. This is a stretch. But if you might as well write it in. This critical exculpatory evidence was not given to affiant by Lawyer Hilton, Lawyer Love, or Judge Glanville. It's, in fact, same was hidden. Affiant will call Judge Glanville, Lawyer Hilton, and Lawyer Love as witnesses because the jury needs to see and hear how Judge Glanville, Lawyer Hilton, and Lawyer Love how they acted together, perjured testimony from Mr. Copeland, hid Brady Giglio evidence, and worked together to wrongfully convict Mr. Williams. The instruction that the judge has no interest in this case is not true. Mr. Williams will invoke his constitutional right to present a defense and call unnecessary witnesses, including these 3 cohorts. Yeah, cohorts. And 5 p.m. The deadline for the state's reply for Mr. Judge Glanville's recusal is out. And I have not seen anything from any paper. I'll check real quick here. Nope. Haven't. Yeah, no. Nothing as so far. So now the deadline is up. The deadline is up. The instruction that blah blah blah. Cohorts. Judge Glanville must be recused. In a separate motion, Lawyer Hilton and Lawyer Love must be disqualified from continuing this case for their misconduct. They are applying Reed v. State. 55. Yeah, it's 5 p.m. Georgia time, yeah? And I haven't seen any papers. I haven't seen anything. No, the press release. No, nothing. And I haven't seen any request to additionally extend the deadline. I have seen nothing. That doesn't mean they haven't turned it in. It just means I haven't seen it. And to my knowledge, it's not on the docket. But if they turned it in extremely late, we won't see it until tomorrow morning. So let's wait until tomorrow morning or until the news breaks. Judge Glanville, 55. Judge Glanville is a necessary witness also because he handed an unknown document to Mr. Copeland's attorney in Mr. Copeland's presence. Affiant will cross-examine Judge Glanville regarding why he would give this unknown document for Mr. Copeland. The jury needs to hear from Judge Glanville so that they can determine whether Mr. Williams has been given a fair trial by a detached, impartial jurist, as claimed by Judge Glanville throughout the case. 56. Lawyer Hilton will be called as necessary witness because she, like Lawyer Love, met with Attorney Bumpus and or Mr. Copeland for an unknown amount of time, quote, off the record, end quote. Affiant will examine Lawyer Hilton on the promises that she made Mr. Copeland and other witnesses in the past, as well, that are not revealed to Affiant. 57. Judge Glanville and Lawyer Hilton, working together, attempted to have Mr. Copeland dressed in civilian clothing to appear before jury as a witness. Why would Judge Glanville care how the state's witness, Mr. Copeland, appears before the jury? This is specifically true since Judge Glanville did not do the same with an earlier witness, specifically Mr. White, who testified in jail clothing. That's interesting. That's really interesting. That means Judge Glanville is fully aware that they need Mr. Copeland to be as believable as possible. You don't get there in jail clothing. '58. Judge Glanville and Lawyer Hilton speak for each other. Lawyer Hilton answered Mr. Copeland's question on whether he would be, quote, locked up for this. And Lawyer Hilton responded in front of Judge Glanville, so long as you testify, we will get an order to get you released. Judge Glanville remained dutifully silent as Lawyer Hilton explained that she/we would obtain an order to have Mr. Copeland released. Judge Glanville, Lawyer Hilton, and Lawyer Love are one. What's going on here? No. Stop doing that. Let's see. Why does that appear like that? I'll see if I can find it in the other one. Yep, yeah. I'll have to go by this instead. Are one and inseparable as they violate all of the named constitutional rights of Mr. Williams and the respective oath of office. Again, Judge Glanville and Lawyer Hilton handed Attorney Bumpus documents, who then gave to Mr. Copeland unknown documents. The affiant will again examine Lawyer Hilton and Judge Glanville on the witness stand on the contents of these documents and why they were given and the reason for putting pressure on Mr. Copeland to testify against Mr. Williams. The jury has the right to know whether Judge Glanville has committed numerous ethical and unlawful violations. Judge Glanville must be recused. 60. These are not the only times that Judge Glanville has shown bias against Mr. Williams and or his counsel. 61. Judge Glanville initially refused to release the transcript of this ex parte hearing that occurred in the chambers on June 10th because he claimed same was quote-unquote privilege. Obviously, that statement is ridiculous. Yeah. It is so ridiculous because attorney-client privilege are the discussions between the attorney and the client in private. This is in judges' chambers with the court reporter. Everything said in front of the court reporter cannot, by definition, be attorney-client privilege. '23 alone. Is the response coming today? I haven't seen it. Does that mean they haven't filed it? It just means I have still not seen it. Let's see here if... No. Nope, nothing yet. Nothing yet, as I can see. '62. Additionally, Judge Glanville must be recused automatically since he defended his position against Mr. Williams' motion to recuse filed on June 17th. '63. This honorable court, Judge Krause, must also be recused as she sits on the Fulton County Superior Court bench alongside with Judge Glanville and has accepted re-election campaign money from Judge Glanville. specifically receiving $2,000 in April 2024 from Judge Glanville. This occurred during Mr. Williams' current trial, which commenced on January 4th, 2023, is ongoing. This has already been denied. She is staying on. Because there's a Georgia Supreme Court decision that election campaign fund must be excessive, and $2,000 is apparently not excessive. In my personal opinion, folks, no judge whatsoever should contribute to another judge's re-election. Why? Because it should never matter who's running for judge. You should, as a judge, you accept your re-elected or newly elected judge. You should have no saying whatsoever in who is being. First of all, it's a madness for me to know that you elect your judges. They should be appointed by competence alone, not election. But since you have that system, another judge should never contribute to a judge should never contribute to another judge re-election. And 64, swear that above is true and accurate. Okay, let's move forward to. This is the transcript. We already read that. I want to see. I want to see his immunity deal. Where is his immunity deal? What's this? Oh, that's the motion to set aside contempt. That's. Where is that? Where is his? Where is it? Certificate Exhibit E, where is it? No! Exhibit F, is it here? Here it is. Here it is. This is Mr. Copeland's immunity. In the Superior Court of Fulton County, State of Georgia. Order pursuant to OCGA, blah, blah, blah. The State of Georgia having moved this court pursuant to this to compel the testimony of witness Kenneth Copeland and District Attorney Phony T. Willis, having determined that the testimony of Kenneth Copeland is necessary to the public interest. Kenneth Copeland having been properly subpoenaed to appear before this court to testify, and the State of Georgia having provided this court sufficient reason in support of its motion to compel the testimony of Kenneth Copeland, this court finds that Kenneth Copeland has been properly subpoenaed to appear before this court to testify in the trial of the instant case, and that the testimony of said Kenneth Copeland is necessary to the public interest. Accordingly, it is hereby ordered that witness Copeland shall appear before this court beginning Friday, June 7th at 9 a.m. and provide testimony in the trial on the above styled case, and shall continue to appear and testify until released by this honorable court. Further, pursuant to this paragraph, said Kenneth Copeland shall not be excused on the basis of the privilege against self-incrimination from testifying or producing any evidence required. However, no testimony given by Kenneth Copeland as required under this order, or any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under this order, shall be used against said Kenneth Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under this order. This part here is He's immune to the things he's asked about in this court. Now, if he testifies to an unrelated crime, then he doesn't have immunity, in my opinion. Kenneth Copeland shall be subject to prosecution or penalty or for forfeiture for any perjury, false swearing or contempt committing and testifying or failing to testify. Now we know this is a false. This is a lie, because in the ex parte meeting they promised him to not prosecute. And here his immunity deal. He can be for perjury, false swearing, or contempt. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court of the states, United States, or any other state. He is not required. That doesn't mean if the question is asked and he answers. A verbal, as Matt says, a verbal promise is worth the paper it's written on. If it's not on paper, never happened. Oh, hey, John. I'm sorry for butchering that name. I never learn how it's pronounced, and everybody pronounces it differently. Jean Lee, or Lay. Jean Lay. Thank you for becoming a member. Thank you so much. You now have access to all my members-only content. Yay! And with that, thank you. Thank you so much. Thank you so much. Now, if anybody else is thinking about this, access to all my members on the content. And so thank you so much. Thank you so much. And yeah. Ooh. Now, while we are at it, let's have one of these. It is hello, folks. Oh. This channel survives on a bit of an ad revenue, but mostly because of contributions from you guys in super chats, memberships, gifted memberships, or via PayPal. My PayPal link is on top of the chat. And this has this year allowed me to get new stuff, new mic, new camera, but also I'm going on a road trip across the United States in August. I will start in Houston, then New Orleans, then Montgomery, then Atlanta, then up to Knoxville, then up to Indiana, and then up to Michigan. It's an 1,800-mile cross-country road trip, and I will record stuff. I will stream from places if I get the free Wi-Fi. And when I'm in Atlanta on August 14, infamous Sylvia has promised to bring me into court so I can sit on a bench in court and watch the proceeding if there still is a trial. And that is just over a month away. So thank you so much, folks, for allowing me to do this. Thank you so much. And that was the end of... All right, let's continue. Finally, it is ordered that should said Copeland refuse to testify after this order is entered, Kenneth Copeland shall be subject to being adjourned in contempt of this court and shall be subject to commitment by this court to the Fulton County Jail until such time as said witness purges himself of contempt by testifying as ordered to do so by this court and this order. This order shall be entered in record of the minutes of this court, and any testimony given by Kenneth Copeland pursuant to this order shall be transcribed and filed for permanent record in the office of the Fulton County Clerk of Superior Court. So ordered June 7th. Yes, Michigan. When will I be in Michigan? Around June 18 or 19. Probably 19, June 19. All right, that was, let's see what this is. Yeah, this is recusal. Oh, yeah, written response. Yeah. Let's see what else is here. Oh, this is a mail. This is the mail from Mr. Melnick, who says, I've been Mr. Copeland's attorney. He tells me that he repeatedly told you that when you were questioning him. I also spoke with Don Geary extensively about Mr. Copeland when he was assigned to this case, and I spoke with Ms. Love early in the process around the time jury selection was beginning. I have a plea with your counsel tomorrow 9. I will come to the courtroom as soon as I'm done. So this is also from Hilton to Melnick. This seems to also be in contention that had Mr. Copeland actually told Miss Hilton that he didn't have representation. It seemed that that is in contention, which means Miss Hilton is a witness by this piece alone. Yeah, all right. Whew. My voice held up. Yay! My voice held up from this entire reading. And still no news about the state's reply. It is 11:20 p.m. here, and I have work tomorrow, so this is all you get from me today. But if tomorrow morning, if that order or that reply is in, I will make a new stream about it. Okay, thank you everybody for being here. Thank you for allowing me to do this. It's thanks to you guys that I actually do it. So thank you from the bottom of my heart. And what can I say? Hug your family, folks. Unless your family's crap, then screw them and give your love to the people who deserve it. Okay? I will send you off with the Yeet the Judge song. And after that, I will be sending you over to watch some tornado chasing. Yay! Okay. Thank you again. See you later. See you tomorrow. Thumbs up, subscribe, all the YouTube things. Okay? Bye-bye.
Gavel cracks, breaking backs, twist the facts, yeah. Rotten core, buried deep, justice cheap, hell. Crooked smile, snake and trial, deception, vile man. Power trip, crooked grip, lose your grip now. Symbol of grief, all from the steed. No more lies, mask, disguise, greed ain't no creed. Yeah, the judge. From the bench today, no more lies, corrupt decay. Yea, the judge, watch him sway. Truth will rise, make him pay.